different
Jacoby,
charges.
Two questions on that. One is your answers to Justice Jackson about the contract approach, as you're calling it. You argue you win under contract principles. You don't argue that they don't apply.
Correct.
So why doesn't this defendant get a remand to argue contract?
We win categorically. The subsequent sentence that the defendant receives is never a basis to find that the contract is against public policy.
If I might, the Fifth Circuit hasn't addressed that question. Nobody has addressed that question. This Court hasn't addressed that question. Why wouldn't we remand to allow the Court of Appeals to address that question?
I think what Petitioner has asked this Court to do is to say that in some instances an appeal waiver could be against public policy, and I'm asking the Court to say it never could.
No. What Petitioner is asking us to say is the Fifth Circuit's rule that there are two and only two bases is not correct, and that I should be allowed to try a contract defense. And you say you've got good contract defenses. God bless you. How about litigating them?
To make it a possibility that they try to raise a contract defense, I think Petitioner needs to show how any contract defense could, in theory, in the right case, give relief here. And there is no public policy that an appeal waiver violates based on the subsequent sentence.
But if we're not prepared to decide that in the first instance because no court has passed on that question, do you object to a remand to have a court?
Very strongly object to a remand, particularly because of what it would signal about the facts of this case. You could say it may be possible in some case, but we would really urge you not to suggest that it would be this case, because this is the type of appeal that even the circuits that have broad standards, I think perhaps accepting the Ninth Circuit, would categorically not find as a miscarriage of justice. And if you suggest otherwise, that truly will open the floodgates and cause a big problem.
Because an issue that hasn't been litigated should never be litigated. Okay. All right. And then you tout the benefits of these deals. Well, let's take this case as an example. The defendant here pled guilty to one count of stealing $32,000. He was sentenced as if he was guilty of all the counts the government dropped and $500,000 worth of stolen money. How, if I think about this as an unconstitutional conditions possible problem, we normally say that there has to be some nexus between what you're giving up and what you get, and some proportionality. And if he's being sentenced as if he committed all the crimes that weren't charged, it's pretty hard for me to see what benefit he's getting from an appeal waiver here. Can you help me with that?
Absolutely. So, first of all, on unconstitutional conditions, there is no constitutional right to an appeal.
There's a statutory right.
Yes, but it's not an unconstitutional condition if it doesn't burden your constitutional rights.
As a matter of due process, you're entitled to that statutory right.
I mean, no, I think that you're just constitutionalizing the appeal right if you say that as a matter of due process you're entitled to the statutory right.
All right. So
but setting that aside, I think your second question is
I think maybe you better set that aside, for my purposes at least.
Understood. Setting that aside, your second question I think is about if he got a good deal in the end here. If in fact the sentence that is one that his bargain to drop 9 charges proved to be a good deal, as my friend has said, he obviously thinks that it ended up not being a good deal, but that is not a basis to undo a bargain. And that's not a basis to find a bargain to be unconscionable. Unconscionability isn't about harsh results later when it proves you made a bad deal. Unconscionability is about a deal that you made that at the time you made it is so one-sided, no rational person would enter into it, and that was not this deal.
If the government's position is a defendant can knowingly and voluntarily give up his appeal rights, I wonder what the government would say a defendant couldn't give up. Could a defendant give up, for example, his right to go to church after his conviction, or to own a gun after his conviction, or his entitlement to federal unemployment benefits after his conviction?
Again, this comes back to my point that this is not an appeal waiver is not an agreement to be sentenced unlawfully. An agreement to be sentenced unlawfully would be against public policy because performance of the agreement would be against public policy.
That's an interesting test. Okay, so if it's an unlawful sentence, he should be able to appeal.
Not at all. No. If the agreement is to receive an unlawful sentence, that is an agreement against public policy. But here the agreement is not to receive an unlawful sentence. The agreement still contemplates that the judge is oath-bound. Right. It's an agreement that the final decision-maker on your sentence is a district court, and that is not an unlawful agreement. No public policy forbids the district court from being the final decision-maker on your case. That was the status quo for 100 years.